Everyone.
There, right? Is that what you said?
Thanks for coming. We get started. My name is Rob Keast, and I'm a co-founder and co-editor of Republic 3.0. We're a new online policy resource and forum for those who care about practical solutions to make government and the economy work better. We look out for thoughtful alternatives to the divisive rhetoric that too often grips Washington. We work to cull through the noise, search for the best ideas wherever they're sourced, in nonprofits, academia, and think tanks, and industry, and from Capitol Hill. We write and cover the ideas working now on the ground to improve people's lives and the state of our nation. Public trust, as we all know, has ebbed to all-time lows for government, but practical policy innovations, ideas that are pro-growth, pro-opportunity, broadly appealing, and fiscally responsible, are still blossoming across the country. As America enters our third full century, only the right kind of governance will drive our nation's future success. So we hope you'll check us out at republic3-0.com. So this is why we're happy to host a discussion today on an emerging issue in intellectual property, design patent reform. With that, I'd like to turn things over to our moderator today, my fellow co-founder and editor of Republic 3.0, Ann Kim.
Thank you. So I'm going to begin by showing you one of the most famous design patents that has ever been granted. As you can see, it's a patent on the Statue of Liberty. And as you can also see, it was granted in 1879. So the idea of patenting designs is actually not new. In fact, it's a very old idea, but it's also an idea that's become increasingly relevant in modern innovation. So it's probably still the case that when most of us think about patents, we're thinking about what the Patent Office calls utility patents. You know, those are patents that protect what a machine or invention actually does. But design patents, on the other hand, protect what something looks like. And in fact, what that something looks like is the innovation itself. So it means that the Coca-Cola company can patent the shape of a bottle. And it means that Lego can patent the shape of an individual block. And in the past few years, the number of patents like these that we have seen has actually grown significantly. So for example, between 2009 and 2013, the number of just applications for design patents has jumped by 40%. And in March, the US Patent Office issued its 700,000th design patent, and it went to the inventor of the Leapfrog GS. And if you've ever been around little kids, then you've probably seen one of these. So some of the biggest holders of design patents today are also some of the biggest global names, both in tech and in manufacturing. So we're talking about companies like Microsoft, Nike, Samsung, Google, Apple. But while all of these cutting-edge firms are using design patents today to protect their intellectual property, the system they're still using is more than a century old. And in many ways, it really hasn't changed since the patenting of the Statue of Liberty back in 1879. And that's the reason we're having this briefing. If you're looking for the next frontier in patent reform, is likely going to be on this topic, on designs. You know, how we treat design patents, both now and tomorrow, is going to have major impact on how US companies innovate and whether they will have the right incentives to do so. In fact, we're already seeing those impacts. So let's just take litigation as an example. You know, Apple versus Samsung. It's a case many of you might have heard of, and it's probably the best known court case so far that specifically involves design patents, and we're going to hear more about that today. But there have been other lawsuits involving high stakes, big names. For example, Daimler over the smart car, the Crocs company against Walgreens. Walgreens had a rubber shoe that looked a lot like a Croc. Kohler over sinks. The number of cases that we're beginning to see are no doubt going to grow as design patents become more important and the stakes begin to get higher. So as many of you in this room know, the next round of patent reform is still under debate, but that's good news. It means that there's potentially an opportunity here to bring design patents into that current discussion and possibly bring about some needed improvements. So our briefing today is going to be in two parts. First, we're going to hear a basic primer on design patents and the structure of design patent law from David Gerk, the United States Patent and Trademark Office. And then we're going to hear from our panel of experts who are going to discuss some of the emerging issues they see and offer up their ideas for change. And then we'll follow that up with questions and discussion from all of you. So with that, first I'd like to introduce David Gerk. His full bio is in the packets that all of you have received at this event. David is a patent attorney in the Office of Policy and International Affairs at the U.S. Patent and Trademark Office. He is an advisor to the Undersecretary of Commerce for Intellectual Property, and he also advises the director of the USPTO on both domestic and international IP issues. He is also leading the USPTO's implementation of the International Hague Agreement on Industrial Designs, an important development which you will also hear more about. So with that, I'll turn things over to David once I can swap slideshows.
Thank you, Anne, and thanks to Republic 3.0 for the invitation to come here and speak. As was mentioned, I'm hoping here to provide you a quick background, just some baseline, so we're all at least working from the same point, might have a diverse expertise on this subject matter. So I'm going to jump right in with that. 4 quick things I'm going to try and hit today to bring us all up to the same point. First off, the difference between the different types of intellectual property, difference between utility patents, design patents, trademarks, and copyrights. And of course, each of those in law school is an entire semester. So I have about 15 minutes and only part of my presentation of that. So obviously, you're only going to get the tip of the iceberg, but at least we'll all have a little bit of a starting point. Second thing I'm going to touch on briefly is the process for granting U.S. design patents and also utility patents. The actual process is quite similar, but there's some nuances going in each of those compared to each other. The third thing I'm going to mention very briefly is just some trends in design patents. And again, Anne has sort of hinted towards some of those stats. I'll touch on that a little bit and maybe flush that out a little further. And finally, some international developments, the biggest of which is the Hague Agreement, but there are some other developments going on the international front with respect to protection of design across the globe. So right here, this one slide is a quick overview of the different types of IP. And I have a toolkit or a toolbox up there because I think that's a nice visual to think about these different types of IP. Just like when you're building a house, carpenter might use a number of different tools to accomplish what they're trying to do. Same can be said with these different types of intellectual property. So the topic we're focusing on today is design patents. When you think of design patents, you should think about ornamental appearance. If you can remember that, you're always going to be in good starting point for designs. So, hey, we're going to protect the way it looks. Something looks cool. We're protecting really that appearance, not how it operates, but its appearance. And the statutes that are cover design patents focus on protecting designs with respect to articles of manufacture. The common word, or what we think of as products today, is a good general synonym for that, but it doesn't necessarily completely cover everything. Second one we're going to talk about is utility patents, and that's probably when people think of patents, what people think of, that's those functional inventions, your machines, your methods, your products, and also improvements thereof. So of course the car was invented a long time ago, but we keep making improvements. We make them go faster, we change the engine technology, so it's not just inventions, but also improvements thereof. Next type of IP that commonly comes up is trademarks and trade dress. That has to do with the source of origin for something. So that trademark is an indicator to the public, and they associate that with the source of goods or services. Another concept in trademarks that's important is distinctiveness. And trademarks also involve designs, sometimes in logos, branding, things like that. So you will see design from a broad concept with respect to trademarks. And finally, copyrights. Copyrights covers original works of authorship, so we probably think books, we think songs, but it can get into products as well. For example, if you have a shoe with an intricate design on, if you focus just on some of the pattern on the upper of the shoe, you could protect that with copyright. And of course, it has to be fixed in a tangible medium. That's a legal terminology, but the point being, you have to have actually fixed it. It can't be a floating around idea in copyright. So that's the major areas of IP in about 30 seconds or 2 minutes, and there's a lot more to talk about, but we're gonna move on. This is just for educational purposes, and this shows how one product might have a number of different IP protecting it. And regardless of the brand, whether it's Samsung or Apple or whoever, it's very likely this might be going on. And I only use phones because it's, again, a popular topic in the news. But this is probably true of shoes or whatever product you see out there. So on the left, you see there's design patents related to a smartphone, and it has to do, for example, with the shape of the product itself. Also, in the litigation that's famous, the Apple-Samsung litigation, there's designs covering what's referred to as graphical user interfaces and icons. The appearance on the screen there, that's a growing trend of popular designs to protect. On the right, you see utility protection, how the phone operates. Remember, functionality, that's that utility protection. And finally, trademarks. A visual image representing a source of origin there is trademarks. So you can see in this one slide we have all kinds of different types of intellectual property protection, in a sense, working together to protect this development by companies and individuals. All right, next we're going to move very quickly here to the examination process. And I'm going to scare you when I show you this slide. This is the PTO examination process. I'm not going to go into all this detail, but this is what we show, for example, when we're explaining to other governments what kind of process we go through in examining patents. The important part is with design patents and utility patents, they generally go through this process, where on the left column is pre-examination, it's called, where you receive an application, you make sure things like fees, all the materials are there. There's also a security review done, and I'm probably going to mention that perhaps later in our discussions, because that's something that might be of interest moving to the future. That center part is the actual examination process, where examiners look at the design patent application and decide whether the applicant should receive their design patent, or if there's problems with it, for example, if it's already existed before and they're trying to claim protection for something that's already in the prior art. And then finally on the right side is post-grant publication. Here's a graph displaying some stats. As was indicated, design patents keep growing. You can see one downtick that correlated to the 2008-2009 financial crisis, and of course everything went down a little bit there. But otherwise you can see a general trend up, 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 and we keep hiring new design and patent examiners to try and keep up with that so we can issue design patents quickly. So I've now covered the first three items. The last area is, I think, one of the more interesting aspects is the international design developments going on. And as was mentioned, that's an area that I'm spending a lot of time with currently with the Hague Agreement. How many of you in the audience are familiar with either the PCT Agreement or the Madrid Agreement in patents or trademarks? Anybody? Just a few of us nerdy folks. Well, what those are international treaties that allow applications to more easily pursue protection across many jurisdictions. So IP rights are jurisdiction specific. If you get a patent in the United States, all you can protect is United States use and making and all the typical things that might be infringement. If you don't pursue protection elsewhere, then others are free to use that technology because patents and trademarks and what have you are territorial in nature. What these treaties do is they assist applicants in pursuing protection abroad more economically. Of course, there's different languages, there's different requirements, and these treaties set forth simplified requirements so that if you file, for example, either one application and designate different countries, you can begin pursuing protection with that simple procedure. So here's how you would normally have to pursue protection for design under pre-Hague, without the Hague Agreement in place. And basically what you have to do is you have to go to every country and you have to file an application there, or in the EU, and that's difficult, time-consuming, and also there's language requirements, burdens. If you don't speak a language, if you go to Japan, you'd have to file in Japanese. So that's the current state. And it's done, but it's, of course, a little bit more difficult, time-consuming, and what have you. So with that in the background, the concept of the Hague Agreement is that you could file with WIPO, which is the World Intellectual Property Organization, a single international design application, and that would lead to a single international registration, and you could check boxes that would designate countries you want to pursue protection. And that's an easier gateway into receiving protection for your design rights. So we won't go into it. This is sort of a flow chart of how you would pursue protection through the Hague Agreement. The bottom line is it's much more streamlined and cost efficient, and this will be an option in the near future in the United States. We're working towards implementing that, but you will still be able to pursue design patent protection according to the domestic route. And last two slides, I'm going to just show you a map. These are countries, the blue and red are countries that are members of the Hague Agreement. You'll see the United States isn't in there, and there's a number of large economic locations where protection of your design rights probably would be desirable, namely China, Japan, Canada, Russia, the ASEAN region down in the South Pacific. The good news is all those countries and areas in the next 2 years are expected to become members of the Hague Agreement, including the United States even sooner than that. And so areas where companies and innovators hope to protect their innovation will soon have a much easier time or a more efficient mechanism to hopefully pursue that. So with that, I don't want to take too much time, and I want to leave some time for my fellow panelists, so I'll conclude there. Thank you.
Great, thank you, David. And for questions for David, we will hold until the end when we have the Q&A for all of the panelists. So now that we're all experts on design patents and the differences in IP, I'd like to turn to our expert panel. We have with us today 3 distinguished experts on intellectual property and on design patents in particular. Again, you will find their full bios in the packets that we've given to you today. I would also encourage you to visit our website, republic3-o.com. Our panelists have each contributed an op-ed to our website, and there's also a Q&A with David, which has a primer on design patents. Some of the information that he had shared with us today, you will also find in the website on the piece that we did with him. So each of our panelists will be giving some brief opening remarks, follow that up with a moderated Q&A to get the discussion going, and then hear from all of you. First up is Rebecca Tushnet. She is a professor at the Georgetown University School of Law, where she has been on the faculty since 2004. Rebecca has published extensively on a wide variety of legal issues in intellectual property and on design patents in particular. One particular article to draw your attention to is a especially influential article on design. It's called The Eye Alone is the Judge, Images and Design Patents. Rebecca?
So thanks. So my background really starts in copyright and trademark, and my main interests are in what role design patents should be serving in the overall intellectual property scheme. Right now, design patent has some unique features, and not all of them are justified. But I want to start from the question, why the overlap? So we have a slide showing multiple forms of intellectual property protection for the same device. And there are reasons for each one. At least for copyright, we might want to encourage expression. For utility patent, we want to encourage technical innovation. For trademark, we want to protect consumers so that they know what they're buying. And what do we want to do with design patent? What is it that we want to encourage or protect? Once we have an answer to that question, we will have a much better idea of whether the current system is meeting those goals. And I think that's the question that hasn't really been addressed in a lot of recent discussion. So as both speakers noted, the numbers of design patents are going up. This inherently raises some issues of quality. So actually, could I see the other slide? Yeah, so this is a design patent that was recently issued for a cup holder. And on the next slide, there's the other views of it. Right, so this innovation might suggest that it is not at all clear how we're supposed to judge what is novel in certain designs once you start proliferating the numbers of them. So I suspect you think you've seen this before. even though it was only recently patented. And right now, the judicial standards for what's protectable are somewhat in flux. The courts, the Federal Circuit has said that the former test looking for a point of novelty, something that's new in the design, shouldn't apply, and your design still has to be new, but you no longer have to specifically identify the part that's new. Among other things, this can create certain conflicts with our other regimes. So, for example, with the Statute of Liberty, the copyright is now available to protect sculpture, which the Statute of Liberty is. But we know it would protect the whole article. Likewise, with utility patents, there's a doctrine, they're supposed to protect things that work. But right now, design patent law tries to exclude things that should be within the realm of utility patents with a doctrine called functionality. But functionality doctrine is a little unclear, and there's a completely different functionality doctrine in trademark law. So there's a potential for some conflict there. More careful thinking about that could really help people figure out what they're free to do and what they're not free to do. So there are kind of three issues I would like to highlight. First is that unlike the Statute of Liberty, many design patents today are only covering parts of an article. So when you look at the design patent on the Statute of Liberty, you understand it's the whole thing. Now, increasingly people are getting design patents on aspects of an article. So imagine instead a design patent on the crown of the Statute of Liberty. This makes it much harder for other people to figure out what they're free to do. And it gives, if you have multiple design patents, it potentially gives you multiple paths to argue infringement. One might say multiple bites for the apple, right? The second big issue, which is related, is the increasing number of design patents on interfaces. So that's actually the first slide. Sorry about that. So that is a design patent that was recently granted to Google. And one interesting thing about doing this for computer interfaces is I'm now infringing, right? Because this isn't a design patent on a statute. It's a design patent on an appearance on a display. So merely by showing this on a computer, I'm suddenly infringing this patent for the display. And if that seems weird, especially since you can't press the play button and have anything happen, then we may need to rethink what we mean when we say we're granting design patents for interfaces. Finally, and related to the other two, a big issue right now is damages. So unlike every other intellectual property damages scheme, the design patent damages have been interpreted to mean that if there's an infringement, the plaintiff gets the entire profits from the infringing article, no matter how sure we are that the infringement had no relation to the profits that were made. In every other field, you can get statutory damages or you can get actual damages, but someone who proves that their profits weren't related to the infringement isn't required to pay over those profits. And this makes design patent a much more powerful weapon than it probably should be, especially given its importance to sales of various things like, so if you infringe the patent on the utility patent on a phone, you may have to pay a reasonable royalty. But if you infringe a design patent on something like that, it's one of the 20 icons on the phone, you have to pay the entire profits from the phone. And that seems out of whack, and it's something we should think about fixing.
Great. Next, we'll hear from Julie Hopkins, who is the partner and chair of the intellectual property practice at Tydings and Rosenberg LLP here in Washington, D.C. Among her achievements, Julie is the chair-elect of the Maryland State Bar Association's IP section, and she has taught at the Maryland Intellectual Property Legal Resource Center. She's also appeared several times on Capitol Hill in briefings like these and has also published widely. Julie.
Thank you. So I've been practicing intellectual property in private practice for a little over 10 years, both on the patent prosecution side, which is the acquiring of patents for my clients, as well as on the litigation side. And I think it's interesting that I've seen in my practice an increase in interest by my clients for filing design patents. It used to be no one was really interested in design patents. When they came and asked for patent protection, they really wanted utility patents. And I would say, actually, I have 2 clients coming up later this week who are meeting with me about filing design patents on inventions that they have. So this is like this is huge as far as what I've been seeing in the trends over the years, and I think it reflects the chart that was up, the graphic that was up on display a little earlier. So I was asked to focus today on transparency of design patents and provisional damages, which I think goes hand in hand with transparency. So there's been a renewed focus. I think we thought patent reform might have been dead on Capitol Hill, but it came back. I'm sure a lot of you are aware that the Troll Act has come up in the House, and there's been discussions on the Troll Act. So we might be seeing more patent reform in the future. And along with that discussion, really focusing on patent trolls has been the issue of the quality of patents that are coming out of the Patent Office. And again, the focus has been on utility patents, but I think the quality of patents coming out of the Patent Office, as has already been discussed a little bit here, should also relate to design patents. And to me, I think that's where transparency really comes in. In contrast to utility patents, design patents are kept confidential during the pendency of the prosecution process. So while they're going the back and forth with the examiner, they're kept confidential. Design patents usually issue in under a year. Utility patents can be pending at the Patent Office 3 to 4 years. Utility patents publish in general, and I won't get into all the rules, but the basic models, they publish 18 months after filing at the Patent Office, and so those applications are then available online for you to be able to see, for you to access and look at all of the filings in the prosecution of that patent application. You are also available to submit third-party submissions to the Patent Office during the pendency of that patent application to be considered. So, for example, the examiner will conduct a search to see whether there is prior art, which is what we call prior art, so pre-existing published patent applications, issued patents, products on the market, journal articles, that type of thing, that might pre-exist the invention, and so you might get a rejection based on novelty or obviousness. Third parties can now contribute to that consideration and that review. A lot of times your competitors know more about what's going on in the industry than the examiner might have time to search on their own. And so by having this third party submission during the publication of the application, the thought goes you're inherently going to get better quality patents coming out of the Patent Office through that process. Right now, that is not available for design patents since it's available, but they're not public, so you wouldn't know to submit any prior art to be considered if you have no idea what's actually pending at the Patent Office right now on the design front. Additionally, during that pendency, if an infringement occurs, so if you find out your competitor is infringing your utility patent during the publication, during the pendency of that patent application, you're able to get what are known as provisional damages or reasonable royalty for the time of that infringement during the pendency of the application. You cannot assert a patent until it issues, but this is a way to get a reasonable royalty and damages for that pending time period. That is also not available for design patents during their pendency. And I bring this up because I think why not? Why shouldn't this apply to designs? So I think that it would make a lot of sense to harmonize with the utility patent system to have design patent applications published during their pendency, and then to also allow for provisional damages for that time period. And the Hague Agreement was mentioned earlier, and one of the provisions, two of the provisions of the Hague Agreement are that applications that are filed during the Hague process, when they reach WIPO, the World Intellectual Property Organization, they are published, and so the public can see those applications, and also provisional damages are provided for that pendency while they're public. And since I actually thought that the U.S. had signed on to the Hague Agreement, my understanding was it was in December of 2013, but maybe you can tell me if I'm wrong, that maybe certain provisions have been signed on, but not the whole thing.
No, we signed on, but until we become a member, which we have to deposit what's called an instrument of ratification. It's the official treaty document that will trigger the full membership, and then our statutory Patent Law Treaties Implementation Act of 2012 will take effect, and we will be a member, and all that will start.
The full benefits of membership. Fantastic. Okay, so we're on the same page. Okay, great. So the U.S. eventually will be able to take part in this. What I think is interesting is the Implementation Act that you just mentioned. The U.S. changed the term of the design patent from, was it 14 years from issuance, which is the current term of a design patent, to be 15 years from issuance, which is to keep us harmonized with the rest of the world. The U.S. has consistently amended its intellectual property laws to be consistent with what's going on with our neighbors, with the rest of the world, including publication at 18 months of utility patents, including aspects of the American Invents Act, which just last year changed us from a first to invent system to a first to file system, and now to change the term of a design patent. So I think that the U.S. should look to the Hague Agreement, look to the world, how the world handles design patents, and consider going to publication of design patents that are filed here in the U.S. and also allowing for provisional damages. Thank you.
Thank you, Julie. Wrapping up is Jeff Manne. He's the Executive Director of the International Center for Law and Economics in Portland, Oregon. In addition to this title, Jeff is also a lecturer at the Lewis and Clark School of Law. He's also a senior fellow at Tech Freedom and a contributor to the Hoover Institution's project on commercializing innovation. Jeff.
Thanks, Sam. I think what I want to try to do is maybe offer some thoughts about the right framework for assessing patent issues generally, but some of these design patent issues in particular, and along the way comment in particular on the issue of damages for design patent infringement, and then also an issue that hasn't been raised too much, but that kind of straddles the, in an interesting way, the international and domestic issues is ITC, International Trade Commission enforcement of design patents. So let me just start out with this sort of framework point, which is to say, there's a lot of emotion, there's a lot of anecdote that animates the patent debate and moves for patent reform. And the existence of those things doesn't mean that the advocates of those views aren't correct, but I just want to just sort of call for rigorous empirical evidence before we jump into transforming our patent regime wholesale, or even changing particular rules without knowing that the change will actually improve upon the status quo. There's a lot of logic behind it, but some of it is a little bit misguided, and I will point out one thing in particular, which is that the idea that we generally need sort of weaker patents, more opportunities to challenge patents both before and after issuance, sounds like a recipe for diminishing the amount of litigation and the threat that patents allegedly impose on subsequent innovation. But it could have the opposite effect. But arguably, what we want is very strong patents over which there is an incentive to license and to negotiate, so that we have these well-defined patents that are ultimately licensed to aid in subsequent innovations. I can expand on that a little bit more, but I just want to raise this issue that is not so clear that what we need if the problem is excessive patent litigation is weaker patents. Arguably, what we might need is stronger patents. When it comes to design patents, I think there are some particular issues, though, that are really worthy of consideration in this regard. And one is, as I mentioned, this question of damages. In some ways, the different damages treatments in design patents is a sort of historical accident. So right off the bat, we should be a little bit skeptical that there is a good justification for a different treatment with respect to design patents than with others. But whether by accident or not, let me just point out a couple of things to think about. Number one is that arguably we should be a lot less concerned with deterrence of subsequent innovation in the realm of design patents than in utility patents. If a follow-on innovation is precluded based on a utility patent, we lose, well, the utility of that patent. But for a design patent, the possible loss of some future design kind of pales in comparison to the possible loss of utility patent implementation. And even arguably, what we actually want is to very strongly deter copying of designs in a way that we don't necessarily want to deter copying of utility patents. At the most extreme limiting case, take a standard essential patent. If it's essential to the implementation of a standard, we absolutely want everyone who's in this space to be able to implement it, to essentially copy, not without paying for it, or following the terms of the standard setting organization that enforces it. We want them to copy that. But when it comes to design, we want to see sort of as much new innovation as possible on the theory that there is more than one way to design a smartphone, for example. And we'd like to incentivize as much investment there as possible. That's never the case. We never want as much as possible. We always want the optimal, but just consider that there might be a different kind of calculation when it comes to design patents than utility patents. And then, so let me just, because I know that if I had the opportunity, I would talk for 4 days instead of 4 minutes. Let me just jump kind of incongruously over to the ITC issue that I mentioned and raise again a kind of a concern with design patents and raise the possibility that this disparate treatment of design patents and utility patents or the effective disparate treatment because of procedural or practical issues is something that we should consider. In the case of ITC enforcement of patents, the ITC issues exclusion orders, which basically, glossing over a lot, means the Border Patrol gets to look at stuff coming into the country and decide whether or not it violates one of these exclusion orders and keep these things out of the country as a result. It happens, again, for better or for worse, that ITC exclusion orders on utility patents are fairly narrowly written, often, but not always, identifying precisely the infringing items. And on design patents, they're much more broad, they're much more vague, and we leave it to the Border Patrol to, again, glossing over a lot, open a box, pull out the thing and say, yeah, those corners are pretty rounded, let's keep that out of the country. Now, that is not exactly how it works, but kind of is, and raises the risk that with design patents, because of how they are enforced and because of how the exclusion orders are written at the ITC, we may have a greater concern than with ITC exclusion orders with respect to utility patents, that we are doing an appropriate job enforcing these orders. Something to consider. I'm not someone who thinks that we shouldn't have enforcement of any patents at the ITC. In fact, contrary to what most people think, I think the enforcement of standard essential patents is the ITC is perfectly suited toward that. But on design patents, I raise some questions as well. So.
Well, 3 very different perspectives on designs, and as you can see, we were only scratching the surface here. So I think I'd like to begin actually by asking the panelists to respond to each other a little. Rebecca, your presentation was unique in that you particularly pointed to a more fundamental, potentially much more fundamental problem with the idea of patenting designs at all. So I'd like you to elaborate a little bit on that and panelists to respond. And for the rest of the panel, what is the role of design patents then in this broader framework of intellectual property? Are all these problems fixable?
So I should say I'm actually not opposed to the existence of design patents, but a big unanswered question in our policy is, why do we want to have them? What is it that we're trying to encourage? And the usual answer, and how other countries often treat them, is as encouraging industrial design rather than shoving them in the patent category where they don't necessarily fit. We just have this name for historical reasons. And I think actually that ties into the last presentation, which I think I disagree with in a number of particulars. So usually we think that absent some important reason, like the need to encourage production of certain kinds, people do better when there is competition to provide a particular product or service. So we get better paper clips when lots of different people make paper clips, even paper clips in the same shape. Then you get the different colors, you get the different sizes, and you get the cheapest, best made paper clips. That's usually what we think of as the free market. Now, we do restrict that to encourage production of certain things, but it's not clear to me that right now the way we're doing that is working very well, particularly since, and this is another thing, even if we want well-defined rights, and I think this is something of a mirage. Literally, when we try to define rights, they tend to retreat as you approach them, because you can always invent new questions about what the contours of the rights are. But it is very important to distinguish between validity of rights and scope of rights. They're two very different things. You can have a valid but narrow design patent or copyright or whatever that is infringed if literally copied, but not otherwise. And that is, in many ways, easier to handle than a right that is infringed by being reasonably similar. And right now, particularly because of these patents on small aspects of things, we risk running into that situation. So I think the point about, are the corners rounded? Well, that's a really broad test. If no matter what the phone looks like, if it's got rounded corners, there's an infringement issue, then you have a problem in the market and a problem of people who don't necessarily want to infringe getting too close, especially since one can imagine that the alternative to rounded corners are not necessarily that saleable. So I guess I would just say we need to consider the extent to which we think that we want people to be competing to provide us even good designs, right? How much of that do we want versus giving people monopoly rights over design? Because it turns out, there's still a lot of reasons to innovate in design anyway. So the example of fashion is one that a lot of people use, where there's plenty of innovation in fashion, even though there's a very limited intellectual property protection. Being the first mover tends to be an important incentive, and so on. So that's, I think we need to think harder about that, because design patent has been neglected for so long.
David, how do your examiners respond to what Rebecca is saying?
Well, I will address that, but I want to make one further comment just to elaborate for those who may not be familiar to the original question: why do we have design patents? And for background purposes, protection of industrial design or design is not something that the U.S. does uniquely. Virtually every country provides industrial design protection, and frankly, it's required under the TRIPS agreement and other international agreements. But what's important to keep in mind is there are different ways that countries protect it, as was identified. And the two major ways, or the two broad ways, are there's registration systems, like is done in Europe, which is you file your application, there's no examination, they stamp it and they shoot it out the door as long as you have all the documents in place. And later on, there's fights about, are you entitled to the design, were you the first, all those sorts of things. And that's how that system operates. The United States, Japan, and some others operate an examination system where all this is done to some extent in the front end, and then rights are issued. So there are a little bit of two different mechanisms in that regard. And I think one of the reasons we have this design protections in place, whether through registration or design patents, is that if you look at trademarks and copyrights and utility patents, those really are tough to protect design innovation. And in today's world, design innovation seems to be an increasingly important thing, especially as products and devices get more complicated. I don't know about you, but I have no idea how this device does what it does, but I can look at the outside and it might have some simple user aspects or visual things that are particularly helpful to me. And maybe that's something to give some thought in thinking about the design protection. And I'm sorry, as far as examiners, you were asking?
Right. Rebecca had raised some concerns about quality. Like, what do your examiners do in that regard?
Our examiners, from our perspective, do an excellent job of examining applications, and they do have requirements. There's a lot of back and forth when drawings are deficient. There are printing issues, and that's more of an IT issue, and that's something we are working on from that respect. And there's also a certain time window. Now, the examiner can only search for so many hours before that's the scope of their search, and they use all the technology. But for those who've litigated IP cases, they know that that's when companies or inventors or opponents will turn over the globe to find prior art that might be buried in a library in New Zealand or wherever. And so The response is, I think the examination process is quite good. There are time limits and resource limits. There's only so much time that can be spent on an application. But as IT improves for printing quality and things, I think you'll even see better patents coming out as far as the visual aspects of it.
Can I clarify that I was not trying to disparage the quality of the examiners,
No.
but exactly with the resource constraints and the increased numbers, then your chances are just go up of getting something weird through.
And Julie and Jeff, I'd like to ask you to respond, and then we'll go to the audience.
Sure. I wanted to respond to your comment about the fashion industry. I think that's a good example of an industry that doesn't quite fit into a nice niche. Whether okay, so you might get trademark protection on Louis Vuitton, but the shape and style of a dress is not necessarily going to be protectable under any of the current existing protections that are out there. And the fashion industry is not happy about it. I mean, they've constantly been trying to find a way to get protection for fashion design. So yes, they still innovate. Yes, they still come up with, seasons are what constantly now. It's no longer 2 seasons in a year. It's every time you turn around, there's another fashion show. But I think that they're concerned. They're being copied, and they don't have proper protection. So I think that still is, if design patents covered what they did, I think they'd be pretty happy about that. If copyright covered what they did, I think they'd be happy about that. So I just wanted to comment on that. I also think that we do want to encourage innovation in the design space. I mean, people own Apple iPhones because it's a very stylish phone. It's more, people are copying the Apple phone because people like the way it looks. And we want to encourage that. We want to encourage companies to not only innovate on the technology side, but to also innovate on the design side. And so I think we want, and this goes back to my publication comment, that publication allows competitors to see what other competitors are doing and encourages them to design around what's already been filed. And we want to encourage that activity. I completely agree. Do we want protection on a rounded rectangle? That to me seems way too broad, and I'm sure most of you would probably agree that, question whether that's eligible for protection among some of the other slides that we've seen up there. But I definitely think design patents play an important role, and we do want to spur innovation by providing protections to innovators in the design space.
I agree with what Julie just said, and I want to sort of echo again something I think that, David, you said this, and I think you picked up on it as well. Sort of answering this question, why we might think it's still a good idea to have design patents despite all of these apparent threats, is that because a lot of consumption decisions are based on design, it is arguable, although I don't know that anyone has looked at this empirically, right, which is really what I want you to take out of all of my comments is we really should understand this stuff before we regulate it. But I do think a lot of people make their consumption decisions and the like on the basis of design. Even if all we care about actually is the utility patents, the reason we give a utility patent is because it gives people the ability, that are producers or implementers of the patent, the ability to realize a protected return from the market, which requires people to buy stuff. And if they're buying stuff not on the basis of whether you've implemented any particular IEEE standard, but rather whether your phone looks like this, then arguably design patent is a really helpful adjunct to ensuring that even if all we care about is utility patents, that they are getting sort of what they are supposed to get. Whether that's actually true or not, we don't really know, I don't think, unless there's studies out there that I don't know about.
Well,
but we also don't know about the other side of it, of course, right? That Rebecca says that we want people to compete, not sort of hand them monopolies. Well, it's well understood that you can have just as much competition in competing for the market rather than competing sort of in the market, and competition to be the one who gets that monopoly can lead us to as competitive, if not more efficient markets than we would have if we didn't have these so-called monopolies out there. It is not sort of this simple dichotomy that we're making a trade-off between giving some protection and facilitating competition. And this is very key to understanding these debates. It's really answering empirically the question whether we're achieving the objective of more competition and more investment and more innovation or not. And you can't assume that we're not because, patent equals monopoly.
Right, so let me just clarify. So first of all, I think we do have some empirical evidence. For example, there are empirical studies of the fashion industry. So it's one thing to say that there are players in the fashion industry who would like a new right. Of course they would, right? It's another thing entirely to say that if we gave them that new right, we'd get a bunch more innovation and new designs. And the empirical studies we have suggest that that's not true. And we actually can compare. It's a difficult comparison, and it's not perfect because legal regimes across countries and cultures across countries differ so much. But, we do have empirical studies of innovation in fashion, and, America is an innovative fashion economy. So we know something about low IP spaces. Fashion isn't the only one that's been studied. So, it is true that our information is never certain, and our empirical evidence always will have gaps, but I don't think that should deter us from looking at things that are working better and working worse.
So I'd like to go to the audience now for a few questions. Yes, and please stand up and identify yourself.
I'm Professor at Ohio State working as a fellow on the House Science Committee. But two questions for you, David. One is, does the Hague Agreement apply to utility pattern? And my second question is, as an inventor, I know it may take several years before you hear from the patent office. It will take a couple of more years for it to be fully executed. What is the reason for delays, and what is it being done to address that?
Thank you for your question. To answer your first one, the Hague Agreement governs industrial designs, and that's the specific spoke of the Hague Agreement, and so it does not pertain to utility or functional inventions. So, sure, but the Patent Cooperation Treaty does. So that's a similar mechanism. The three mechanisms, we have some symmetry. A lot of developments on the international front kind of mimic each other because of the successes. So there's the Patent Cooperation Treaty, which deals with utility patents, the Madrid Treaty or Madrid Protocol, which deals with trademarks, and the Hague Agreement dealing with designs. And each of those for those respective types of IP sort of do the same thing, facilitate entry into these countries to pursue protection.
But my experience is, if I want a protection in Japan or Europe, I have to apply separately. And we have done that in the past. I don't think there's one application I can make which will provide me protection overseas.
My answer to that is you're still technically applying individually there. It's just you're using this treaty as a mechanism to apply there. So in the instance of the Hague Agreement, you will file an application with the World Intellectual Property Organization. And then if you would like to pursue protection on that slide, I colored in some countries. If you wanted to pursue protection there, you would what's called designate those countries, and you'd pay a fee. The more countries, the more you pay. But WIPO will literally send the application to those countries, and under the treaty, they're forced, as long as you've met the WIPO requirements, which are standardized, to begin reviewing in whatever their national system is, those applications. So technically, you're exactly right. You still technically apply with those individual countries, but you can do it through these mechanisms. And each of those have slight nuances in them, but it is an efficiency mechanism that does exist.
You can do that for utility?
Through the PCT agreement, yes. And that, again, is a whole complicated, we could spend 2 days discussing the nuances of that, as my colleagues, I'm sure, could verify for you as well. But I'll just touch on his backlog question. I think it's pretty well known, many of the efforts the PTO has undertaken in both hiring examiners and other PPH, Patent Prosecution Highway, which is a way applicants can expedite prosecution. There's different paths of prosecution for applicants who really value quicker prosecution, different tracks. So there's a wide variety of tools. And again, I think that's a topic, a little bit off topic. We could spend a whole day on, so I don't want to spend too much, but happy to talk afterwards with you or something.
So there was another question.
My name is Matthew Ketron from Senator Gerber's office. Thank you so much for your words, David, and the group panel. My question has to do with the Geneva Act as well as the Hague Act. kind of following on his coattail.
Sure.
TTP is being widely discussed. There was a briefing just last week on it. I know one of the aspects of the treaty is patent harmonization. What are your expectations with how this is going to impact your trade or your practice?
That's a good question. Just for clarity's sake, and only because I've lived the last couple of years working on The Hague pretty much every day. The Geneva Act is one aspect of the Hague Agreement. It's the most current act, and so when you say Hague Agreement and Geneva Act, it's really one and the same. It's just sort of like in a series of however you want to think of it, and that really is the main act that countries are signing on to now. It's like an updated version of the Hague Agreement. As far as the word harmonization, anytime you have an international instrument or treaty that countries join, they're going to always tweak their practice, first off to comply with it, but then also for efficiencies. And to that extent, I think that the Hague Agreement has the possibility of having some commonalities or best practice, or if you want to use the word harmonizing effects. And I can say that both firsthand and hearing from other countries what they're doing. When you join the agreement, there's a set of rules you have to comply with and practice. And so I think you will see somewhat of a streamlining, a little bit of design practice. Of course, the Hague Agreement and particularly the Geneva Act I'm referring to, one of the key reason it was signed was really to allow design patents and registration systems to coexist under this international treaty. So I'm not sure you're going to see this harmonization that one might either want or not want or whatever you're hoping for, because it was really written to have a lot of tolerance to individuality in the design practice. So I hope I addressed your question on that.
General question, I think.
No, that was a great question.
Yes.
Hi, I'm Francine Freeman. Rebecca, you mentioned damages a little bit, and that under the design standard right now, you're not allowed as a defendant to demonstrate that a sale might have been made for reasons other than the alleged infringement. And I know included in the packet was an amicus brief that you signed on to. Can you expand a little bit for the audience about how courts might be able to remedy or interpret the current statute to allow this?
So, I mean, honestly, the best way to do it would actually be for Congress to make clear. So the damages provision was written at a time when intentional infringement was required for damages. So sort of penalties were to be expected. And when the practice was to put a patent on the entire article. And that makes a pretty big difference, too, in what kind of damages are reasonable, especially if you think that the design really is selling the product. Now that we're in a world where you have the little parts and where unintentional infringement is equally actionable, we have a bunch of decisions saying that it's still the case that you should award the entire profit and there should be no apportionment or anything. A sufficiently creative court could reread the history and say, look, based on congressional intent, we really need to start reading the definition of infringement to include sort of an aiming at what the infringement was. So you could get all the profits from the infringement, that is, the thing that you did that violated the patent, but not all the profits from the article as a whole. And courts have done much more creative things with less outcry. So, it's not impossible that a court could do that. But honestly, a legislative clarification would be superior.
Right. Any other questions? Yes.
Hi, my name's Kyle, and I'm from Congressman Brandon's office, and I kind of wanted to marry the two ideas of damages and the Hague Agreement. To what extent does the Hague Agreement open up U.S. manufacturers and designers to kind of the small add-on patents that could lead to unintentional infringements?
I'll take that one. It will have, I would say, literally no effect because the U.S. and others will still be performing their review or examination. One could argue if you make it easier for applicants to get an IP right, design patent sufficiency, then I guess arguably you make it easier in that regard. But the Hague Agreement itself is not doing anything other than making it more efficient for applicants to pursue protection in that regard. And you raise an interesting thought in the debate of registrations versus utility or registration systems versus design patent systems. One of the aspects of an examination system is arguably by going through that examination, you make it more difficult for whatever the term you want to use, overly aggressive litigation or what have you, because of the hurdles you have to go through. A registration system, and we see this in some other international jurisdictions, if it's too easy to get right, people who maybe aren't entitled to them just hoard up all these rights, even if they're not entitled to them, and you have to work backwards to try and undo that. There's differing opinions on that, but that's some thought that's been raised.
Anyone else? Jeff. And Jeff, if I can ask you to use your mic, we're recording this for posterity, so. Apologies.
Do I have to? There we go. I can hear myself now. Lucky you all. I was actually going to sort of follow on that question actually for David, if that's okay. Although I'm happy to comment as well, and just sort of ask. So my understanding, although I'm sure there's some dispute around these numbers, is that design patents are granted at something like 98% of design patent applications are granted. In fact, I've even seen people suggest that we have a sort of de facto registration system. And so at the same time, despite the conversation that we're having and Exhibit A, the Apple Samsung case, we do have these indications of kind of these threats, like we're going to have these big future problems, but they don't really seem to be here yet. So I'm just wondering if you have any sort of explanation, or if you can unpack why we're granting 98% of these applications. We haven't seen enormous problems. Obviously, examination is going on. I think right now design patents are granted after about 14 months or something like that, faster than utility patents, but still 14 months. I don't think that's because they're just sitting around doing nothing, although some of the time I'm sure they're busy, right? So I don't know, can you, do you have a kind of a comprehensive sort of story that fits all of that together, or is it just happenstance, or the real problems that might emerge haven't emerged yet?
I don't know if it was for me. Was that for me?
It was for you.
I'm sorry. As far as I don't have a thought or feeling that there are problems. There's differing opinions. The story is that in the examination of design patents, your numbers are pretty much right. Less than a year is the typical pendency, and there's certain, as you saw that complicated chart I had put up, just an application working its way through there, obviously getting docketed and then searching prior art, and there's, believe it or not, to do things efficiently, there's a certain, not backlog, but a certain number of applications you have to have in a queue. Otherwise, you can't have examiners just sitting there and then waiting for one to come in the door. But that's exactly right. And the majority of problems with applications are drawing issues where lack of clarity or non-full description. Prior art rejections in design aren't as common perhaps as utility cases. I think part of the nature of the beast just in what you're claiming a specific visual versus broad claim language that might say, a machine that goes up and down, and that's easy to reject or find prior art. So that's probably the best I can do in painting a picture as to what's going on, and so that's from our view. That's what's going on.
So can I ask you a question since we have you? So
looks like we're out of time. No.
With respect to our international obligations with trademark, we did end up with a system where we get sent the international application, and actually if the PTO doesn't reject it, it then issues. So it's a sort of negative option. And as I recall, especially early on, that created some problems with sort of just accidental things where the PTO didn't act fast enough and then didn't actually examine them, but they had to issue because of our international commitments. So can you talk about that possibility with respect to design patents? Are we going to be asked to do that?
Sure. The Hague Agreement, as Rebecca correctly identified, it also has that concept as its basis, and that's sort of more aligned with the registration system. However, there's what's called declarations countries can make, and that gives sort of further options. And so through those declarations, it's expected that the U.S. Could make, is going to make, and there's already, the Senate has already given advice and consent on this with respect to examination. There's no intention that the U.S. will be granting any design patents without examining them, so that's not a concern. But that concept, as we discussed, did carry over from treaties and is in the Hague Agreement, but there shouldn't be concern that you're going to have a whole bunch of design patents issuing that haven't been examined by the USPTO.
Right. And so we actually are running out of time, so we'd like to ask the panelists for one last word. This event was about potential changes that we would like to see in the system. Design patents have been kind of ignored in the patent reform debate for a while. So we'd like to ask everybody to think about the worst case scenario. If design patents continue to remain off the table, what's going to happen to innovation? Jeff, you alluded to this, 15 years, 20 years down the road, whenever these problems could arise, and why do we need to address these issues? So Jeff, you want to start and go on down?
Well, I'd like to sound a note of caution about these issues. We can identify these as we have the sort of structural issues that are potential problems, but they may not be. And I want us to be really careful before we go around reforming the system that may operate better now than it will post reform. The one thing that I would say we should laser-like focus on, and I think we've all sort of alluded to or explicitly discussed this, is whether the line between design and utility patent and the corresponding line between the entire profits damages and reasonable royalty damages and other differences between them, whether that actually makes any sense. I mean, that isn't the only place you could draw the line. Perhaps utility patents should actually be subject to an entire profits rule instead of the reverse, right? That, to me, is really the key question to ask. If it's just a matter of historical accident, was it a lucky accident, or should we do something about it? But that's where we really should focus on where that line is drawn.
I think worst case scenario is that you're going to see more overly broad design patents being issued, and which is going to lead to more litigation, which is, as we've seen from Apple versus Samsung was the perfect example, is very expensive. And so I think that as much as we want to encourage innovation, we want to encourage people to get protection, we also don't want to necessarily encourage massive amounts of expensive litigation as well. So that to me is what I see as worst case scenario.
So I'm going to say something a little different. So anything that can't go on forever won't. So if design patents and design patent liability continue to expand and Congress does nothing, eventually courts will start inventing limits. It happened in utility patent. It's happened somewhat in copyright. It's happened somewhat in trademark. And so after billions of dollars in litigation, we will end up with a system that is different. And I can't predict what it'll be like. I like what happened in copyright. Maybe I'll like what happens in design patent. But it won't be done in a comprehensive, thoughtful way. It'll be done based on the cases that come in front of the courts, because that's how courts decide cases, and they do their best. So something will happen, but it won't be planned.
David, if I could ask you to focus yours on the international aspects and what the rest of the world is doing.
Sure. That's a great question, and I think the Hague Agreement, we've spent a lot of time on it, and a couple aspects. The provisional rights aspect was mentioned, and I think that's going to be very interesting, seeing how that plays out. And I think it provides a lot of opportunity, and it does have some attributes that applicants like speed, and it'll be interesting to see how that plays out. So maybe along the lines of Jeff, maybe one of the thoughts is to see how, in making these decisions how that plays out, and we're hopefully going to be a member very shortly. And on the global market, I think all the countries are really looking to continue designs in the public sector becoming increasingly important and newsworthy and what have you. It's also happening on the government level where countries seem to be spending more time focusing on that. So I think looking forward, I think you're going to see countries having designs as part of their conversation and thinking how they can always improve their system. I mean, if nothing's broken, that's fine, but there's always little tweaks you can make here and there. Especially as technology evolves. So it'll be interesting to see how this plays out. But I'm very excited, and I think applicants and the public should be very excited about the Hague Agreement, because I think it really might have a real interesting effect.
Right. We'd like to thank our panelists for being here today. I'd like to thank all of you for coming. And in the next few months, when you begin to hear more about design patents, you can say you heard about it here first. I encourage you all to visit our website, republic3-o.com. We have a package on design patents in particular that is live on our site, and it includes some pieces from panelists who are not here, from those who are not here today, as well as pieces from our panelists as well. So please take a look, and thank you once again. Have a great afternoon.